Hi, my name's Melanie Thorley and I'm a solicitor at MJT Law. Today we're going to talk about what happens at conciliation. Now I'm just going to jump into a Google page and I'm just going to put, oh, it's already there, Fair Work Conciliation, Fair Work Commission Conciliation. This is about an unfair dismissal conciliation, but it's just going to be a really high level idea about what's going on. So when we think about conciliations, we talk about the next step. You file an application, it could be an unfair dismissal, it could be in a general protections division, or it could even be a conciliation at the Queensland Human Rights Commission. Now, apart from the length of these conciliations, the format is almost always the same. The conciliator will bring everybody in. If it's an unfair dismissal or a general protections application through the Fair Work Commission, it is done over the telephone. If it is a Queensland Human Rights Commission conciliation, then out of COVID times, it's normally done in person. Queensland Human Rights Commission conciliation is normally, give or take, about 3 hours long. A unfair dismissal conciliation is about 1.5 hours long, and a general protection conciliation is around 2 hours long. Now, the conciliator will start when everybody is together by talking about what the conciliation is about today, the role of the conciliator, and the fact that everyone's here today to try and get a resolution. They're going to talk about it being without prejudice, that's all confidential, and it gives you a chance to be able to express some concerns without the fear of it coming back to you later. The conciliator will almost always say if there is a resolution that is found, then the conciliator can help prepare what we call a deed of settlement, which is the agreement between both parties as to what the deal was at the conciliation and how to resolve this going forward. That will almost certainly have a mutual non-denigration, a mutual confidentiality, and almost always a mutual release of all things in relation to employment. Okay, so when we're thinking about it, to get ready for the conciliation, I'm just going to go scroll down here, and it just says here how to prepare. This is actually a really good description of how to prepare. You've got to be available on the scheduled date. If you're not going to be available, you need to notify all the parties involved that you're not going to be there and see if you can arrange alternative time. Sometimes that's possible, sometimes it isn't. It says here set aside a quiet place. Now this is in relation to the telephone conciliations with the general protections or the unfair dismissal with the Fair Work Commission, and during COVID times it would also mean for the Queensland Human Rights Commission. What it means is be in a quiet place that you can set aside 1.5, 2 or 3 hours to do this conciliation. Have the paperwork in front of you. Now, you would think that you understand your case really well, and you probably do, but when you're nervous and when you're under stress, you're going to forget things. So put those documents in front of you. If it's an unfair dismissal, put the Form F2, which is your application, the Form F3, which is their response in front of you. If it's a general protections, you've got a Form F8 or Form F8C, and then you've got the Form F8A response. If it's a Human Rights Commission, then you've got your application and their response. Whether you do that electronically or not, it's a really good idea to have those documents in front of you so you can refer back to them. Request an interpreter beforehand if needed. This kind of goes without saying, if you struggle with English language, this conciliation is going to be in English and you're going to need someone to assist you to interpret. So you just make sure that you're going to get that interpreter there, ready, on time, to assist you during that conciliation. Then there's a little bit about how the conciliation is conducted. The conciliator is going to be, first of all, asking the applicant to speak first, and then they'll ask the respondent to talk, and in some situations they'll ask the applicant to speak again. That's after the conciliator has already done their opening statement. Once all the parties have had a chance to kind of aerate their own issues, the conciliator will more than likely break both parties out into what we call shuttle mediation. They're the private mediation environment, where if it's on the telephone, then the conciliator will normally hang up on the respondent and keep the applicant on the line and continue talking to the applicant about what the applicant wants, so that conciliator can take that applicant's wants and needs and offers back to the respondent. And then they'll hang up on the applicant and then call the respondent. The respondent gets to do the same thing. Now, the applicant's not going to find out what the respondent says during these private sessions unless they notify the conciliator to directly tell the applicant or the respondent, the other side, what happens. It is not normal for the conciliator to go ahead and talk about everything that happens in these private sessions. They are literally private. Once that has come to its conclusion, whether it's exhausted all opportunities to come to a resolution or there has been a resolution, the conciliator will normally figure out whether there is a resolution or not. If there is, they will bring the parties back together into one environment again, and again that might be done over the telephone or it might be done in person. If it's an in-person conciliation, then of course those shuttle mediations will be done in separate rooms. They'll bring them back together again. They will go over, that conciliator will go over what the deal was, what the agreement was. They might be preparing a document that everybody will be able to sign once the conciliation's over. And then the conciliator will bring the matter to a close. If there is no resolution, then there's more than likely that the conciliator is not going to bring the parties back to that joint session again. They're just going to say there's no resolution, everybody finishes that particular part of this process, and then you've got the next steps moving forward. Okay, this next part just talks about how the conciliator is there to help the parties make a resolution. They're there to provide guidance for discussions, and they're not there to argue any points. The conciliator is not there to advocate for either party. They're not there to form judgments. They might be there to reality check some of the resolutions, but they're just not there to decide whether it's a good resolution or not. Just talks a little bit about what happens after conciliation, which we've talked about. There may well be a 3-day cooling off period, depending on which jurisdiction you're in, and then there's the next steps if it does fail. There's also on this page for unfair dismissals a few videos that you might be interested in watching as well. Okay, so things to take away. You need to think about getting yourself ready, and you might want to bring a support person if you're on your own, making sure you've got all the documents in front of you, so if you do forget something, you can go back and look at those documents again. Have on your mind what you actually want to get out of this conciliation. A lot of the time the conciliator will ask what you want, and that's actually a really important question, so have a think about that before the conciliation itself. And then once conciliation is over, then be prepared to either sign those documents that you've agreed to or think about what the next steps are. Hopefully that's been of help to you today. If you have any questions, you can call us. If you want us to help you and attend that conciliation, we can do so. There's no issue there, as long as there's availability and we've given enough time. Again, have a lovely day. Thanks for watching.